All right, good afternoon, everybody. I wanted to go ahead and start the stream because it looks like the National Council has started their stream early. And today, this is going to be the hearing, the Supreme Court hearing over the election challenges filed by Adam Jones and Lanissa Melton. And with that, I'm going to make the Supreme Court's live stream full screen, and I'm going to hide. If you have any questions, you can pop them right over into the chat, and I'll take a look at them and answer them as best I can. And without further ado, let's get to the show. If you didn't tune in earlier, this is the the Supreme Court's live stream from their webpage, which is creeksupremecourt.com. We don't have any control over the audio or the camera shots or anything like that. It's being streamed from the Mound building is what it looks like. So we're just watching along with you guys, and there's no audio right now because the hearing hasn't actually started. But as soon as it kicks on, we'll feed it in there. Mado for tuning in today, guys. Oh, and if you have any questions, just pop them into the chat and I'll answer them as best I can.
You may be seated. Good afternoon. Court is now in session. The Supreme Court of the Mvskoke Creek Nation, case number SC 2021-07, the combined appeal of Adam Jones III and Lanissa Melton for fraud or irregularities of the 2021 primary election. If I can get this thing off now. During the proceedings today, ones that will be addressing the court, we're instructing you to go to the podium where you can speak. And if you have your mask on when you speak, you may take your mask off, because the court reporter needs to be able to understand what you're saying and hear what you are saying. The appellant will go first. You'll have 20 minutes to speak. If you want to reserve 5 minutes, you can reserve 5 minutes for rebuttal. Do you desire to do that? How much? You want to reserve 3 minutes? Okay. We have a timekeeper. Where's Laura? Oh, there she is. She will have the cards to give you advance of your time. Appellee, do you reserve any time? Full 20 minutes, okay. If we would the appellant please announce your presence, name of the attorney, and who's present with you at the council table? We go to the speak so there's not a microphone there for you.
Your Honor, Carly Griffith Hotvet, counsel for appellants Adam Jones III and Lanissa Melton.
Thank you.
Your Honors, my name is Robert Seacat. I'm here representing the election board of the Mvskoke Creek Nation. I have with me 4 members of the board. I'd rattle off their names, but I'll get it all wrong.
Okay, so you do have 4 national council people here?
Election board members.
Oh,
yes,
election
sir.
Board. Thank you. For the record, we have received the brief of the joint appellants. As appellee, have you filed a brief in this case? Okay. 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 Counsel for the appellant, you may proceed.
Thank you, Mr. Chief Justice, and may it please the court. We're here today not just on an appeal from petitions for irregularities, but to ensure that Mvskoke citizens' fundamental right to vote is protected from infringement, and that voters who did everything right, who followed all instructions, and who timely mailed their ballots are not subjected to unfair treatment through no fault of their own. At least 1,248 votes are uncounted as of today due to significant delays by the U.S. Postal Service, resulting in those ballots not being received prior to the statutory 11 a.m. deadline on September 18th, the day of the 2021 primary election. That number of outstanding ballots represents 1/3 of all voters casting ballots in the 2021 primary election. That number also represents almost 60% of all absentee ballots cast in this election. In other words, only 905 absentee ballots were counted out of at least 2,174 cast. The appellants would request this court to intervene and provide relief, whether the court finds cause to require these outstanding absentee ballots to be counted or invalidate the results and direct a new election to occur. The appellants would defer to this court's judgment. The appellants will present argument over 4 topics: error in the application of factually distinguishable case law, due process violations of the fundamental right to vote, equal protection violations resulting in disparate impact to categorical voters, and public policy exceptions to election laws during the time of pandemic. But before presenting argument, appellants would like to draw attention to the need to review all arguments and application of law in the context of Mvskoke values and cultural mores. to inform the jurisprudence of the nation. Pre-contact Mvskoke characteristics of governance and leadership and selection of leadership focused on harmony, community balance, fairness, and consensus. As Mvskoke people were disrupted after contact, many things were lost to us as we were forced to focus on survival. But as we enter a new era of self-determination and thriving tribal sovereignty, the resurgence of Mvskokean concepts of law, traditional practices, and customs are more critical now than ever as the nation solidifies its identity, establishes a distinct identity, and reflects Mvskoke values.
Counselor, I have a question concerning this argument that you're making about traditional customs and practices and their applicability to the situation that we have today. How do you harmonize the arguments that you're making about traditional customs and practices when in this election it's being conducted by a popular vote? How do you harmonize that?
I'm glad you asked. Thank you. The court should prioritize fairness, balance, and consensus. And while the Mvskoke Nation has chosen to incorporate secret ballots and a popular vote, those concepts of fairness and consensus should still apply when reviewing the election laws and practices. While a first-past-the-post electoral system is usually prohibitive to the concept of consensus, we can still get as close to that as possible by ensuring that all voters are heard and that their fundamental right to vote is protected. So the consideration of those cultural practices and mores should be the lens which we view all of the statutes through. We still read it clearly, but it should be colored by those traditions, mores, and concepts.
Okay, thank you.
First, we'd like to draw attention to the factually distinguishable case law that was applied in this matter. In the King case, there was an irregularity caused by the election board's ministerial, or there was an irregularity asserted as being caused by the election board pursuant to their ministerial duties. And the question...
Counselor, in this situation, though, isn't the irregularity being caused by an independent third party? Like, how is the King case applicable to this situation where, in the King case, the case spoke to irregularities that were being essentially performed or acts of the election board or other individuals under the purview of the Mvskoke Nation that were acting in a way that rose to an irregularity? How is King applicable in this case where the corpus of the irregularity lies with an independent third party outside of the control of the Mvskoke Nation?
I would agree with that, Justice Adams. In this instance, we are arguing that King should not be applied because the U.S. Postal Service is a third party. So the analysis contemplated in King as applied through determining whether there was an honest mistake or fraud involved is not something that the court should have considered when the district court should have considered when reviewing this matter. Since there was a third party that was the ultimate proximal cause resulting in the irregularity, we would argue King should not apply. So the analysis and differentiation between honest mistake or fraud based on election board actions or inactions wouldn't necessarily be at issue. However, we do recognize that if the court were to review election board actions or inactions with regard to their ministerial duty, they could find that there was a failure to mitigate what would be a foreseeable but undue burden on voters with regard to delay in the Postal Service delivery rates. There was considerable public discourse during the 2020 presidential election wherein absentee ballot vote delivery timeframes were of concern, and the election board member and staff testified that they try to stay apprised of current events and issues resulting in the election industry and community, and the election board should have taken note of that and communicated to voters that there was a potential for significant delay in delivery of their absentee ballots upon return, which would be considered a component of their requirement to promote and encourage voter participation pursuant to their statutory duties contained in the election code. If there was a determination that the election board's actions failed to mitigate the potential for this issue, thus infringing on voters' fundamental right to vote and have their ballots count, there could be a foreseeable distinction that the court would need to intervene and perform a subsequent analysis, not of whether there was an honest mistake or fraud, but an interim distinction of whether there was a lack of due diligence on behalf of the election board to provide an intermediate level of scrutiny about whether or not the election board's failure to mitigate was a breach of their statutory duties, and thus a breach of their ministerial duty. In that instance, because there was a breach, because there was a failure that unduly compounded the irregularity resulting in not notifying voters of the potential for delay, there is an issue with King in that application and the standard of review. So we would request the court to consider that. But in the first instance, Justice Adams, we would agree this is a third-party participant and King may not be applicable in this matter. Additionally, the Roberts case also only analyzes actions of Mvskoke Creek Nation precinct workers, not third-party participants, and again, should not be applicable in this instance. In the Johnson case, the court made a review of whether or not the appellants in this matter were able to establish by mathematical certainty an impact to the outcome of the election. In other words, you have to show that person A gets more votes than person B. That shouldn't apply here. We have numbers showing that there are outstanding ballots in a sufficient amount to impact every single contest in this election, with the exception of the question on the National Council referendum with regard to free press. Every single election has numbers that, if the absentee ballots that are outstanding are counted, could be impacted. There is no vote margin wider than the number of outstanding ballots. This is an undue burden on appellants to apply a mathematical certainty requirement because there's no statutory mechanism available to require that these outstanding absentee ballots be canvassed. There's no valid opportunity to conduct discovery, so there's no fair opportunity to be heard. This is a procedural due process violation. In McIntosh versus Mvskoke Creek Nation, this court ruled that an appellant was denied due process as a result of constrained opportunity for discovery. By that constrained due process, the appellants were prevented from being able to make or establish mathematical certainty in this matter. Therefore, this particular issue should not apply. As we move on from discussing the applicability of precedential case law, we'll be focusing on constitutional claims. Primarily, and I'd like to draw the court's attention to this, Article 4, Section 4 of the Mvskoke Creek Nation Constitution indicates that no candidate may be recognized as elected unless they have received a majority of votes cast. Not counted, not canvassed, cast.
But Counselor, isn't your formative argument, doesn't it rely upon what the definition of cast is? So can you please tell me what your definition of cast is?
Certainly, Your Honor. When we look to the Merriam-Webster dictionary, the definition of cast in the context of voting is this formal submission of a ballot. Not the counting of a ballot, not the canvassing of a ballot, the submission of a ballot by a voter.
Yeah, but with all due respect to the Merriam dictionary, but doesn't their definition of cast have to harmonize with the Mvskoke Nation's definition of a valid ballot? And couldn't an argument be made that a ballot is not valid or an absentee ballot is not valid unless it reaches the Okmulgee post office by 11 a.m. on the day of the election?
That argument could be made. However, in the review of election law and additional consideration of constitutional review, I have not found any definition or indication of what cast should be. There is a case law of this court that indicates that if a provision in the Constitution can be plainly read, then it should also be plainly applied. As far as interpretation is concerned, that case law indicates that there should not be judicial activism with regard to an expanded interpretation of the plain language of the Constitution. Now, I recognize what the founders and what the drafters of the Constitution had in mind is not something that's necessarily readily available to us when we consider what the definition of caste is. So the plain language as accessible to citizens and as accessible to the public with regard to the provisions in the Constitution should apply. If we understand that caste means submitting a ballot, not counting a ballot, there is an issue there. The validation of ballots is something that should be concerned. You can't validly cast a ballot if you are not a registered voter of the Mvskoke Creek Nation, if you're not a citizen of the Mvskoke Creek Nation, if you're not 18 years old. There are requirements that are influential as far as determining whether somebody is eligible to cast a ballot, but the actual physical casting of the ballot is distinguishable from a validation of that ballot and from the counting of that ballot.
Counselor, was this issue raised at the district court?
The issue of distinction between the definition of casting a ballot and counting a ballot was raised at the district court.
I don't think she addressed that in her opinion, did she?
I don't believe she did. Additionally, the court may consider federal case law as persuasive in this matter. The court has recognized that voting is a fundamental right, and strict scrutiny analysis should apply to that. That strict scrutiny analysis requires a compelling government interest in a manner that is not the least restrictive manner of influencing that. By having a 11 a.m. statutory deadline, there's an issue with that. It restricts voters' rights to have their absentee ballots counted in a fair manner. And there's also least restrictive means. We don't know what the intent was in setting an 11 a.m. deadline. We would assume for efficiency purposes, but that law was passed in 1999. We're 22 years out from that, and there have been significant increases in technology, which should be recognized. The immediacy of vote reporting is something that is fully capable and able of being reported, not on the day of, but still giving the election board plenty of time to conduct and process additional election data and information. There are least restrictive mechanisms, which I refer to in my brief, but in consideration of time, I have 1 minute left. I'd also like to point out that there's a violation of voters' reliance interest in Bennett v. Yashina, which is before the federal court of the United States. If there is a likely reliance of voters on an established election procedure and a significant disenfranchisement of their vote, that's a due process violation. Here, voters relied on the information that was provided to them about how to get their absentee ballot submitted and counted on time. However, because of Postal Service delays, which is a reflection of a deviation from established election procedure, there was significant disenfranchisement. Again, 1/3 of voters overall did not have their ballots counted, and about 60% of absentee ballots voters didn't have their votes counted either. Thank you.
Counselor, I have a question. Before you sit down, your appeal to this court, is it based on irregularities or fraud in the election itself, or are you advocating for the voters who the votes were not counted because they came in after 11 a.m. on Saturday?
Both, Your Honor. We have to consider—
How can you justify being a spokesman for the voters who are really not a party to this contest?
Sure, Your Honor. The appellants themselves are voters. They cast votes in this election. In addition to advocating for their irregularities petitions, the issues here also look at what the issue is with those irregularities. If the statute itself with the 11 a.m. deadline is found to be unconstitutional, then that statute should not be applicable and should not restrain those absentee ballots from being counted as a component of that resulting irregularity.
Have you brought forth any information, any evidence from a disenfranchised voter whose ballot was not counted?
Not to our knowledge, Your Honor. We do not have information. It was not available to us at the time of the filing. We understand that there is a process the election board has in place for voters to be able to call and check. I'm not aware that a list has been promulgated of absentee voters that have been disenfranchised.
Okay, you may take your seat. You still have reserved 3 minutes for your rebuttal.
Chief Justice, I have just one quick question. So Counselor, so you make arguments concerning the legitimacy of the Muskogee Nation election law and undue burdens that it's placing on voters, and it seems to sound like you're making like some equal protection arguments concerning in-person voters versus absentee voters. But I guess the one question that I have for you in terms of the legitimacy of the 11 a.m. deadline for the absentee ballots, I mean, how would it change your stance if I offered up the proposition that the 11 a.m. time frame is there because the post office closes at 12 p.m.?
That's something for consideration, and I think that is not necessarily something that wouldn't make sense. I also know that there's no indication that that was the intent in the legislative record that was reviewed as far as what the consideration was. And I think we have to view this through the lens of what's fair to the voters. If voting is a fundamental right, are we going to consider all constraints being an issue? The flip side of that is, while it's not necessarily independently an issue that as a standalone consideration would be that bad, but in the context of the other restrictions, there's no alternative for somebody to hand deliver a ballot. There's no alternative for somebody else to submit a ballot on behalf of someone else, with the exception of that person being disabled or homebound. And there's no opportunity for easy recognition or knowledge of a voter to determine if their absentee ballot has been received in a timely fashion, at least not that has been communicated widely to the voting public. So when you consider the constraints on being able to validly exercise the right to vote through absentee ballots, there's a huge issue with the concept of fundamental fairness.
Thank you.
Thank you. You still have your 3 minutes for rebuttal. Mr. Seekad?
May it please the court, I'd just like to start off by saying it's an honor and a privilege to address this body and to be representing the Mvskoke Creek Nation Election Board. In a word, our position today is that after a full and fair trial, Judge Leeds got it right. Under the Mvskoke Creek Nation Code, there is a set of laws that dictate how elections are to be administered. The Mvskoke Creek Nation Election Board has no vested interest in the outcome of the elections that are conducted. They do as individuals, but as a board, they don't have a vested interest in the outcome, the results of the election. Their vested interest is that the elections are being conducted according to law, according to the way the Mvskoke Creek Nation National Council has set out the rules and the procedures for how to conduct an election. In this case, the evidence was clear. The election board followed all of those codes, all of those procedures, all of the law. This issue started out with two petitions for irregularities on 6 different points. Judge Leeds, in her decision following the trial, I think it's fair to describe as summarily rejected 5 of the 6 points. She indicated that the problematic point was this issue regarding absentee ballots and the United States Postal Service, and the fact that a significant number of absentee ballots came in well after the 11 o'clock deadline. I think for our purposes today, I urge the Supreme Court to find that the petitioners have abandoned all points with the exception of their claim for an irregularity relative to the actions of the United States Postal Service. Whereas I tend to agree somewhat with the argument of counsel that factually some of these cases that were cited are distinguishable, but the law still applies. And the law that we're dealing with from King and from Roberts is clear that the petitioners in order to overturn the results of an election, have a very difficult burden. It's a high bar. They have to be able to show to the court that the irregularities were not just mere honest mistakes, but involved fraud. That's the King case. That creates the heightened scrutiny. Now, that's the law that can be applied to a myriad of factual scenarios. I've canvassed Mvskoke Creek Nation law, and I have not been able to find a case that is directly on point because I don't think this situation has ever presented itself before. I think we are looking at a factual scenario of first impression, that being that the United States Postal Service allegedly had processes and procedures that failed in this last election that caused a certain number of absentee ballots to arrive past the deadline. So I'm going to limit my my argument to that one point and talk about the allegations of irregularity relative to the United States Postal Service. First of all, there is a manner with which every citizen of the Mvskoke Creek Nation can absolutely rest assured that their vote will be counted, and that is by voting in person. They come to the voting precinct, they mark their ballot, they watch that ballot go into the voting machines, and they have cast their vote. It has been the law for some time that there is an option for members of the Mvskoke Creek Nation, and it is an option that is solely the voters. They can elect to request an absentee ballot for a myriad of reasons. They don't even have to have really reasons. If they elect to vote absentee, they submit an application and they will go on a list. And according to the rules of the Mvskoke Creek Nation Code, an absentee ballot will then be mailed out to them. They have an option to fill that out and mail it. But when they do that, they are, and it is common sense, I think, they are trusting other individuals, not the election board, not any official from the Mvskoke Creek Nation, but other entities such as the United States Postal Service to deliver that ballot on time and in one piece. There are more opportunities than what I can detail out here, more scenarios than I could list out here in the time allotted of things that could go wrong with that process. But it stands to reason, and it makes common sense that there is the potential for problems when you put your ballot in the hands of someone else and you don't physically yourself see it go in the ballot box.
So Counselor, when you say that there is am I hearing you correctly when you say that there's a primary means by which a citizen can cast a vote, and then there's a subordinate or separate or secondary means by which a citizen can cast a vote?
I don't mean to indicate subordinate, and that would that vote is counts any less than a primary way, but there is a primary way to vote, and that is by voting in person. And there's only one person that can opt to vote by absentee, and that is the voter. No one can make them do it. That is an option that they have to select. They only get sent the absentee ballot if they've opted, they've taken that option, and they've requested an absentee ballot. Then one will be mailed to them, and that goes down, that's recorded. There's a record of the fact that they've requested one and one's gone out to them. So no matter where they live within the United States, even without the United States, and I acknowledge that, that from a convenience standpoint, it doesn't make a lot of sense, but physically, when an election takes place, a voter has the opportunity to travel to Okmulgee, to a voting precinct, to any voting precinct under the Mvskoke Creek Nation, and cast a ballot in person.
So Counselor, what I'm interested in is, are all citizens of the Mvskoke Nation, do they have equal protection under the law, whether they cast a ballot in person or they decide to cast a ballot through absentee means. I just want to be clear because I'd like to hear from you if there is a heightened protection for someone doing it in person as opposed to someone who does it via absentee.
My position is they do have equal protection under the law. However, it was testified to at the trial. In 2017, there were approximately 200 ballots, absentee ballots cast that were not arrived by the 11 o'clock deadline. In 2019, there was around 300 that came in after the 11 o'clock deadline. I believe it was Nelson Harjo that testified. He's actually received an absentee ballot almost 2 years after it was originally cast, fairly recently. And I believe that was relative to the 2019 election. So someone that chooses to vote absentee is putting the ability for that vote to actually make it to the Mvskoke Creek Nation in the hands of someone else, not the Mvskoke Creek Nation, but some other entity, and things can go wrong. The rules, as I'm sure you're very well aware of, is that they cannot, the board cannot mail out an absentee ballot any earlier under the rules that existed when this election took place than 20 days before the election. So that absentee ballot goes out to the absentee voter. The absentee voter then must mail it in with sufficient time for it to make it to the Mvskoke Creek Nation by 11 a.m. on the day of the election. In the past, without petition for irregularities, without complaint, there have been several hundred absentee ballots on prior elections that come in late. It's just a fact of life. Someone who votes in person will never have that situation come up because they are voting right there while the polls are open. There's no question their vote gets here and goes through the machine and is counted. But there's no guarantee, absolute guarantee, that that can happen when one is voting absentee. And so I wouldn't say it's a lack of equal protection of the law. I would say it is the results of a choice made by the voter when you apply common sense. In this case, there was 905, there was 920 to 930 absentee ballots that were received, but 905 that were counted as proper. There were over 1,200 that were received late. It's a lot. But in 2020, we had a pandemic, as we all know. The numbers, the sheer numbers of those requesting absentee ballots went up. It stands to reason that if the numbers of people that choose to vote absentee goes up, the numbers of absentee ballots that come in late will likewise go up. The evidence as to the reason for those late votes, those late absentee ballots, is lacking in anything that would equal mathematical certainty. What we know is 1,200 and some odd ballots came in late. What we don't know, because they weren't canvassed, they can't be under law. The election board cannot open those ballots, cannot count them, cannot look at them and examine them because they came in after the statutory deadline. We don't know how many of those votes were placed too close in time to have reasonably got there. We don't know how many were placed at an appropriate time and owing to the United States Postal Service failures, they didn't get there, they didn't get here on time. We just simply can't know that unless they violated the Mvskoke Creek Nation voting rules and the code by getting in there and examining those ballots.
So, Counselor, how does your argument harmonize with Article 4, Section 4, that says that candidates win by a majority of votes cast? So, from a cast standpoint, like, how does your argument harmonize with the Constitution's requirement that it has to be a majority of the votes cast? I'd like to hear from you, like, what your definition of cast means.
So there isn't a lot of support for the definition between cast and counted. All we can look at is how the absentee voting system works to understand that cast and counted is oftentimes in our law, those are terms used synonymously, and they don't describe different things necessarily. A vote is cast in person when a person comes to a precinct, fills out their ballot, submits it into the machine, and it is counted. That is a cast vote. But a person voting absentee fills it out, mails it, and that vote can't actually mean anything until and unless it arrives prior to the deadline, and then it must also pass scrutiny, because that ballot may not be counted if there is an irregularity with a signature, if there's a whole host of irregularities with regard to how that's put in the envelopes, how it and how it's filled out. The election workers on the board have to look at the signature and make sure that signature matches the signature they have on record, and if it doesn't, then that vote's not counted, and that's always been the system. So this distinction between cast and counted, I don't think furthers our inquiry into this at all. I think we're looking at from a common sense measure, it's not a vote unless it arrives by 11 o'clock and it meets all of the requirements of a valid vote. Then it is considered a cast and counted vote. And it has always been the case that absentee voters may not have their vote counted if there is some irregularity with regard to that process, whether it be signature or when it arrives or other things that could invalidate it. So this thing about we've got to determine cast versus counted, I think that's a red herring. I don't think that actually answers the issue or addresses the issue we're faced with. The issue, as I see it, that we're faced with is, do we invalidate a properly conducted election because the U.S. Postal Service was allegedly slow on a certain number of ballots? Judge Leeds asked that question. She asked at the conclusion of the case, what remedies are available to the district court? And we each gave our opinions. In my opinion, it was either throw the election out in its entirety or make some decision that suspends the Creek Nation Code to go in and actually count these votes after the fact, but that would be suspending the code insofar as that point is concerned. But if the court just invalidates the election in total, that doesn't remedy the situation, because the election board is still duty-bound on a new election to follow the same rules. And the rules were that we cannot mail out absentee ballots prior to 20 days before the election, and that the only method of delivery of those votes back to the election board is the United States Postal Service. We'd be right in the same boat all over again. It wouldn't remedy the situation. And I think this is a good time for me to bring up this point. With regard to separation of powers, the rule makers for how to conduct elections is the National Council. Theirs is the only body to legislate how elections operate. So, and as happened in this case, there developed a problem outside of the control of the board, outside of the control of Mvskoke Creek Nation, that potentially affected a great number of ballots, that being the United States Postal Service. It's my understanding that very recently the National Council has addressed that situation. They have passed amended rules on how to conduct elections in the future. they've caused a postmark by. So if a ballot is postmarked by a certain date and it's received within 5 days of the election date, then it will be counted. That expands that time somewhat. But we don't know how many of the votes cast in this last election, how many of that 1,200 would have been positively affected or how many would have been negatively affected by that. What the petitioners are wanting to see happen is we open those boxes and we canvass and count all of those ballots that came in late. But to do so would set a precedent. And that's the question I posed to Judge Leeds. If you take the avenue of throwing out the election, is it because you're stuck with the fact that there were absentee ballots that didn't get counted in all prior elections? 200 in 2017, 300 in 2019. Where do you set that bar? Because if you invalidate this election based on a large number of late arriving ballots, you've got to set that bar at something. Obviously, it's not 200 or 300 because that's never been an issue before. So is it 500? Is it 600? Is it an arbitrary number? And once you do that, whatever this board does, if this election is invalidated, it sets precedent. And if it sets precedent, it creates a situation where there are unintended consequences for later elections. And it creates more uncertainty and more ability for more petitions for irregularities. Whereas, in my humble opinion, what I urge the court to consider is that Judge Leeds weighed the evidence, applied Mvskoke Creek Nation law, and made the right decision for this election, and that if there is a body to correct something that is amiss that affects the elections, that body is the National Council, as they have done. Whether or not the new rules that they've come up with will appropriately address that, honestly, has yet to be seen, but it certainly is a pretty good attempt at it. There was actually discussion in the trial that, perhaps a postmarked by date is a better way to go about doing it, but there's only one way to make that happen, and that is for the National Council to act, which they've done. And so we believe that is the appropriate response to the events of this prior election, and that the election results should be certified, that the petitions for irregularities should be denied.
So Counselor, at the lower court, were there arguments made concerning whether the appellants are asking for relief that can't be granted?
Yes. Yes, the appellants are requesting that the ballots that came in late, the 1,200 and some odd number of ballots, be canvassed and counted, which is not would not be proper under the code as it existed on the date of the election.
Thanks.
Thank you, Your Honor.
Thank you, Mr. Seacat. You have 3 minutes for rebuttal.
Thank you, Your Honors. We heard that the election board's position in this matter is that absentee ballots are secondary or subsequent to walk-in votes. Now, not only is that not consistent with the election board's statutory duties of encouraging voter participation, it's also inconsistent with their duties to promote voter registration. There's a significant number of Mvskoke Creek citizens who are eligible to vote that live at large. They are disproportionately impacted by the challenges associated with this third-party intervention resulting in so many vote irregularities. It's surprising to hear that the election board would take the position that voters who choose to vote by absentee ballot throw themselves to the will of all known or unknown influences resulting in whether or not their votes are counted. Why shouldn't at-large votes also have equal opportunity and receive equal protection? The other consideration here is it's not surprising to see an absentee ballot request increase, especially during a pandemic. This court itself took action through an administrative order to take a pause and suspend deadlines and suspend in-person access to the court in consideration of that. For absentee ballot requests to increase during a pandemic, it makes sense that more absentee ballots would come in. And we would tell the court that while yes, 200 ballots were late in the second most recent election, 300 ballots were late in the previous election, over 1,200 ballots were late in this election, representing a 400% increase. That is not a proportional ratio.
Do you have any documentation that the COVID is a result of the increase in absentee ballots, or is it speculation?
Speculation, Your Honor. However, we know that there's been significant encouragement of Mvskoke Creek citizens to be cognizant and considerate of preventing the spread of COVID, and absentee ballot voting is one mechanism to prevent the spread by maintaining social distancing. So with that, it's not surprising. But we know that since this is implicated in a fundamental right to vote through a consideration of equal protection, there should be strict scrutiny applied. Additionally, the district court indicated in their opinion that the district court was without remedy. However, this court is the last best stop to perform intervention in the context of a pandemic, in the context of a third-party intervening occurrence resulting in the irregularity, in the context of substantive fairness with regardless to the fundamental right to vote. This court is the last best stop. There's no jurisdiction over the U.S. Postal Service.
What are you suggesting the Supreme Court should do?
So our appellants are requesting remedy through the court, either through counting of the absentee ballots or through tossing or through the invalidation of the results and requesting a new election to occur.
Are there statutory ability for us to go in and order the election board to go ahead and count or canvass the absentee ballots?
Your Honor, there's not a statutory provision.
How could the Supreme Court then issue that order?
That's a great question. We would, defer to the court as far as their ability and authority to consider the fundamental rights of voters as being supreme in consideration of a statutory restriction, which would impact voters' ability to cast a ballot.
You understand that the Supreme Court here is to rule on law, not to make law. We do not legislate from the bench.
Yes, Your Honor. I understand that. I also understand that this court has taken the opportunity to create standards of review analysis and additional case law provisions which inform the statutes and inform the Constitution, and a remedy that would seek absentee ballots to be counted could fall under that. But we also know that the invalidation of the election and the ask for a new election is also something that the appellants would be interested in receiving.
Andrew, any question? Your time up. Thank you. Your time is up.
Thank you.
At this time, the court is going to recess. We're going to deliberate. We will issue an oral order today, to be followed up by a written order tomorrow. And if that being the case, we will stand in recess at this time until the further order of the court.
Okay, guys, it looks like the court's going to go into recess. I'm going to stay with the live stream here and see if they're going to come back out with their oral decision. So we're just going to wait and see what happens with the stream. If the stream gets yeah, it looks like it's shutting off. If the stream gets shut off, we'll keep going for a little bit and see if we can get the decision. Otherwise, we'll have a post later today or whenever the oral decision comes out that will, so we can resolve this case. So thanks for tuning in, and we're gonna keep streaming for a little bit to see if we're gonna get the decision or not. So Mado. Okay, guys, it looks like we're not going to come immediately back, and they've turned their stream off. So what we're going to do is we're going to shut this stream down, and then we'll come back with the oral order either in a video, or if we can get it going on a live stream, we'll set that up. But we'll get the information to you guys as soon as we get it. So, Mado for tuning in, and we'll see you in the future.